Federal employees looking for relief from discrimination must adhere to a unique equal employment opportunity process. This procedure is confusing and unforgiving. Deadlines are tight, and one slip-up may end your case forever. I'll walk you through the process in this video. The federal EEO process applies to nearly all civilian federal employees and applicants for federal employment. The laws covering federal employees are pretty much the same as those protecting non-federal employees, with some minor differences. In place of the Americans with Disabilities Act, employees are protected by the Rehabilitation Act of 1973, also known as the Rehab Act. The two laws are basically identical. The potential reasonable accommodations for federal employees are appropriately broad. Because of its financial resources and size, the federal government has difficulty establishing an undue hardship defense or that reassignment is not possible due to a lack of vacancies. Generally, adverse actions taken against employees due to retaliation are illegal. For federal employees, an adverse action is illegal if retaliation was a motivating factor, even if the adverse action would have been taken regardless. Although the complaint process differs, federal employees are also protected against discrimination based on marital status, parental status, and political affiliation. Complaints against unions must be filed with the EEOC because unions are not federal employers. The federal EEO process is a hybrid of the internal and external complaint processes discussed in the previous videos. Filing an EEO complaint resembles filing an EEOC complaint, except the investigator is also the company rep. You only have 45 days from the date of harm to contact an EEO counselor. In theory, this time period can be extended if you're unaware of or not notified about the time limits, did not know and had no way of knowing about the discrimination, or were prevented from contacting an EEO counselor because of circumstances beyond your control. The reality is that the 45-day time limit is rarely extended. The first step in the EEO process is speaking informally with an EEO counselor. To locate an EEO counselor, check your employee bulletin board or agency's website. Speaking with any EEO counselor is sufficient to begin the process. After talking with an EEO counselor, be sure to follow up with an email. Include each of your issues and bases in your email as discussed in my video about proving your case. In addition, provide an evidence packet to prove your case as discussed in my video about filing a government complaint. By sending this email and brief chronology within 45 days of the date of harm, you can prove you raised all your allegations during the pre-complaint period in a timely fashion as required. The EEO counselor will attempt to resolve the complaint informally. They may invite you to participate in an alternative dispute resolution or ADR program. I'll discuss these processes in a future video. If you decline, your EEO counselor may discourage you from proceeding with your complaint. During this part of the process, the EEO counselor cannot contact your management without your permission. Within 30 days of your initial conversation, the EEO counselor will conduct a final interview to conclude the informal counseling period. With your agreement, your agency can extend the informal counseling period for up to 60 days or 90 days if you participate in ADR. Once you receive the notice of final interview, you will have 15 days to file a formal complaint as described in the notice. Each allegation in the formal complaint must have been mentioned to the EEO counselor during the informal counseling stage. Almost all agencies maintain forms for EEO complaints. Using these forms is not required, but preferable. If you do not use the form, be sure to state EEO complaint and include your name, address, and job title, the agency's name and address, all bases and issues, the dates for each adverse action, the date you first contacted the EEO counselor, the date you received the notice of final interview, and your signature. If the formal complaint form does not provide sufficient space to include all your bases, issues, and dates of adverse actions, attach additional pages. After receiving a formal complaint, your agency will assign an EEO investigator to investigate the complaint. The investigator will begin the investigation by sending you a letter identifying the issues and bases accepted or rejected for investigation. Your agency may attempt to narrow the allegations stated in the formal charge or reject them completely. Issues and bases can be rejected for reasons such as the same allegations were previously stated in another forum, like a union grievance, a claim of discrimination was not stated, or because the allegations are untimely. You can raise rejected or narrowed allegations after the investigation if you request a hearing with the EEOC. If your entire complaint is dismissed for administrative or procedural reasons, you should appeal to the EEOC immediately. The formal charge can be amended later to include any subsequent allegations or adverse actions. These types of amendments are common. At the outset of the investigation, you will be asked to discuss your complaint in detail. Most federal agencies request an affidavit, which is written testimony signed under the penalty of perjury. The affidavit may be comprised of questions prepared by the investigator and your responses. Make sure to add any important information relevant to your complaint that is not otherwise captured in your responses. At times, investigators will ask employees to prepare their own affidavits. In that case, you would take your formal complaint, add some details from your chronology to flesh out your allegations, and submit this as your affidavit. Regardless of the process used to create your affidavit, before signing, ensure that all relevant information is included and every detail is accurate. A responsible management official is the person who took the adverse action. Officially, they do not have the right to review your affidavit before writing their own affidavit. However, your investigator can, and most likely will, permit this practice to assist them with their investigation. Similarly, your investigator may allow you to review the affidavit of the responsible management official and other agency witnesses and provide a response. There are a few reasons your investigation might be closed prematurely. You cannot be located, you do not return phone calls, attend scheduled meetings, or submit requested information. You can always request additional time to respond to an investigator's request. If your case is closed for any of the reasons I just listed, complain to the EEO director and appeal to the EEOC. The investigator has 180 days to conduct an investigation. With your agreement, the agency can extend the investigation for up to 90 days. Amendments to the original complaint can also extend the investigation. If you are offered and refuse a settlement agreement for all the damages you are entitled to, some of your damages will be limited if you win your case after a hearing. I'll discuss damages in a future video. Otherwise, consider whether you will want to appeal in the likely case of the agency investigation stating no discrimination occurred. If so, you should begin looking for an attorney or someone else with experience in federal EEO proceedings who can assist you. I'll talk about how to find an attorney in a future video. Due to the complex legal procedures I'm about to discuss, proceeding through the administrative hearing process without representation can be difficult, and this video is not legal advice. Within 30 days of the investigator's final report summarizing the evidence, you can request a hearing before the EEOC through its public portal. If you do, the EEOC will assign your case to an administrative judge, or AJ for short, which is a neutral fact finder who issues decisions on federal discrimination cases. Although AJs are supposed to issue findings within 180 days, it usually takes a couple of years to receive a finding. For this reason, your attorney may request a final agency decision instead of requesting an EEOC hearing. While an EEO hearing is less formal than a federal court case, some of the same rules apply for motions, cross-examination, and discovery, which is the legal process for exchanging evidence. If you are unrepresented, you appear before the AJ pro se, meaning on one's own behalf. Once you are assigned an AJ, which may take a considerable amount of time, your AJ will typically begin the process by conducting an initial conference. During the initial conference, the AJ will decide if discovery is needed, set conference dates, and possibly dismiss issues. If the AJ decides discovery is needed, the following process kicks into effect. Within 10 days of that decision, you must send your discovery request to your agency. Within 15 days of receipt of that request, your agency must provide the evidence. If your agency does not produce the evidence, within 5 days, you must send the AJ a motion to compel. Within 10 days of receipt of the motion, your agency can issue a motion opposing the motion to compel. The AJ will intercede in the discovery process only if a motion to compel is filed. Although all discovery technically must take place within 90 days, it usually takes longer. Discovery can include a deposition, which is where a witness verbally responds to questions while under oath, a written interrogatory, where you or your agency supplies written answers to written questions, requests for admission, where you or your agency admits or denies written statements, and production of documents. You need to submit a list of witnesses to your agency. Include a very brief summary describing what each witness will attest to. Witnesses who are not expected to support your case should be listed as hostile witnesses. The agency is responsible for ensuring that any witnesses who are federal employees are able to attend the hearing. There are some potential costs during discovery. Each deposition costs about $1,000 and is paid for by the party requesting the deposition. Before the hearing, the AJ will likely conduct a conference call to resolve any remaining issues and attempt to settle the case. When the facts are not in dispute, the AJ can issue a summary judgment, which is a final ruling without a hearing. A summary judgment is much more likely to favor the agency than you. If you are notified that a summary judgment is being considered, usually due to a request by the agency, you must respond. Your request should include your evidence supporting the case, the key evidence supporting the case that you still need from your agency, and an explanation of why the credibility of witnesses is essential, which can only be established through a hearing. In the event that you need to postpone a hearing, you need to inform the AJ in writing and have a really good reason. Submit affidavits from others supporting the reason for the postponement. The unavailability of witnesses is an insufficient reason for rescheduling a hearing, as the AJ can make alternative arrangements to acquire their testimony. At the hearing, expect that you will be asked to speak first. You and your agency will both have the right to call and cross-examine witnesses. Some AJs will allow documents not previously submitted introduced into the hearing. During the hearing, the AJ can direct questions to the witnesses. The entire hearing is recorded and transcribed verbatim. Once the AJ reaches a decision, they will send their decision to you and your agency. Infrequently, the AJ will issue an oral decision at the conclusion of the hearing. Within 40 days of receipt of the AJ's decision, your agency will issue a final agency order. Although an agency can issue a final agency order appealing the findings of discrimination by an EEOC AJ, this rarely occurs. If you are unsatisfied with the final agency order implementing the AJ's finding of no discrimination, you can appeal to the EEOC's Office of Federal Operations within 30 days. The appeal can be submitted online through the EEOC's public portal or mailed to this address. The appeal must use the EEOC Form 573, Notice of Appeal Petition. Include with this appeal proof that a copy was delivered to your agency, like through certified mail receipt or email confirmation. Within 30 days of making the appeal, you should submit a letter stating specifically which agency decisions should be overturned and the reasons why the decisions should be overturned. Upon receipt of the appeal, the EEOC will acquire a copy of the investigator file from your agency. The EEOC often, but not always, reaffirms the decision of the AJ. In some circumstances, the EEOC will reconsider its decision. A case can be reconsidered because new evidence is available, the previous decision misapplied policy or erroneously interpreted law or regulations, or because the previous decision sets a new precedent. If you are unsatisfied by the results of the EEOC appeal, you can still file a lawsuit in federal court. Once all appeals are exhausted by your agency must provide the relief awarded by the EEOC within the time frame stated in the appeal decision. If your agency fails to do so, you can file a lawsuit or petition for enforcement with the EEOC. If your agency breaches a settlement agreement, you must send a letter explaining the breach to the agency EEO director within 30 days. You can file a petition for enforcement with the EEOC within 30 days of receipt of the agency's response, or after 35 days if the agency fails to respond. The petition for enforcement should be sent to the following address. Just a reminder, federal contractors are not federal employees, nor are employees of auxiliary organizations to the federal government, like Peace Corps volunteers. Federal employees can file a union grievance or a complaint with the Merit Systems Protection Board instead of using the EEO complaint process. The process of complaining about discrimination based on marital status, parental status, and political affiliation also differs from the EEO complaint process. You can file a union grievance if you are part of a bargaining unit. Some advantages of the union grievance procedure are that the process moves along rapidly and the union provides representation. Although union stewards sometimes assist with EEO complaints, generally unions are not involved in the EEO complaint process. One potential disadvantage is that you cannot decide whether or not the grievance will proceed to arbitration. That decision is made by the union. Employees working for some agencies can file a union grievance and a formal EEO complaint. The most notable of these agencies are the U.S. Postal Service, FBI, CIA, NSA, GAO, Tennessee Valley Authority, and the Federal Labor Relations Authority. If you wish to file a union grievance, you must act quickly. An employee often has less than 45 days from the adverse action to file a union grievance. The decision of the grievance arbitrator can be appealed to the EEOC. This is the same process I just described when appealing a final agency order. Most employees with a year on the job can file a complaint with the Merit Systems Protection Board. Issues appealable to the MSPB include a demotion, discharge, including constructive discharge, suspension for over 2 weeks, furlough under 31 days, not allowing a return to work after a work-related injury, denial of a within-grade pay increase, and disqualification of an applicant or employee for lack of suitability. In addition to the bases of discrimination covered by the EEOC, the MSPB also hears complaints based on veteran status and whistleblowing. You can file an MSPB complaint within 30 days of the adverse action or within 30 days of receipt of a final agency decision, whichever is later. This deadline can be extended by 30 days by mutual agreement of you and your agency. A case with issues covered by the MSPB and the EEOC is called a mixed case. A mixed case can be filed under the agency's EEO process, which is a mixed case complaint, or can be filed with the MSPB, a mixed case appeal. In a mixed case complaint, the agency has 120 days to investigate. After 120 days, you can appeal to the MSPB. If you receive the agency final decision and are dissatisfied with the results, you have 30 days to appeal to the MSPB. The EEOC does not conduct hearings on mixed case complaints. Unlike a formal EEO complaint, where certain information is required to be included in an investigative file, if you file an MSPB complaint, you must provide all the relevant information on your own initiative. The advantage of the MSPB process is that you do not need to prove an adverse action was discriminatory, only improper, such as the decision maker failed to follow civil service procedures. The MSPB has 120 days to issue a decision on a complaint or appeal. MSPB's formal hearings are similar to EEOC hearings. Hiring an attorney to assist you in this process is highly recommended. After an initial decision by the MSPB administrative judge, you have 30 days from receipt of the decision to appeal, before the decision becomes final. You can appeal to the clerk of the board at this website. After an MSPB decision becomes final, you can file an appeal regarding the civil service procedures with the U.S. Court of Appeals for the Federal Circuit. Discrimination issues can be appealed to the EEOC within 30 days of receipt of an MSPB final decision. Discrimination complaints based on marital status and political affiliation must be filed with the U.S. Office of Special Counsel. Most executive branch employees can file a complaint with the U.S. Office of Special Counsel, but exceptions include employees working for the U.S. Postal Service, FBI, GAO, and certain intelligence agencies. These complaints can be filed online here. Executive Order 13152 prohibits discrimination based on parental status. To pursue a complaint on this basis, contact your personnel office and request a copy of your agency's complaint procedures. There are some resources here on YouTube if you'd like more information. One is the Federal Employees EEO channel, which goes into greater depth about aspects of the federal sector EEO process, which could be helpful if you're representing yourself. On the Fight Employment Discrimination channel, yes, Lisa beat me to that name, Lisa goes into depth about her experiences of experiencing discrimination as a federal employee. She has a horde of tips and suggestions, and her channel is a real inspiration for people who are experiencing the emotional effects of discrimination. Just to recap, federal employees must be careful to comply with the deadlines in each portion of the EEO process, or the opportunity to file suit is lost. Those deadlines again are: within 45 days of an adverse action, speak to an EEO counselor. Within 15 days of receiving a notice of final interview, file a formal complaint. Within 30 days of receiving the investigator's final report, file a request for a hearing with the EEOC. Within 30 days of receiving an unfavorable final agency order, file an appeal to the EEOC's Office of Federal Operations. Thanks for tuning in.